Here.
Here. Here.
Here.
Here. Great. Commissioner Meggs, will you lead us in the Pledge of Allegiance, please?
Pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation under God, indivisible, with liberty and justice for all.
Sorry. Big chair. Did knock you off there. Okay, well, I know everybody always gets excited about the preliminary announcements, so we have our typical preliminary announcements. First of all, we appreciate and thank the First District Court of Appeal for allowing us to use their fine facilities. So please respect their rules, and we have absolutely no food or beverage other than water here in the hearing room. Please also silence your cell phones, and I ask that anyone that will be addressing the commission to be clear in their speaking to us, to speak up so that our recording equipment can pick it up. We regularly get comments from the public that were hard to hear on the live stream and taped audio of these public meetings. So we certainly want everyone to hear all comments made today. If you desire to be heard on a matter, please fill out a speaker card and give it to Ms. Fulford, who is typically in the back. Now she's in the front, and who just had her hand up. Thank you, Ms. Fulford. Okay, next item is the approval of the minutes. Do I have a motion?
Motion. Second.
Commissioner Berger motions, Commissioner Brady seconds. Any discussion? Seeing none, all in favor, please say aye.
Aye.
Minutes are approved. Were there any nays? I guess I should call for nays. Were there any nays? Okay, no nays. Good. Minutes approved. First item on our agenda today, item 4, consideration of advisory opinions. We have 4 advisory opinions today. First is file number 2734. It will be presented by Ms. Klanke, is the requester here for this matter. It is post office holding restrictions, former city council member. Do we have anyone here for that matter? Yes. Come and if you'll stand and introduce yourself, please, sir. You can do so right there if you wish.
Good morning. My name is Jason Gabriel, and I'm the General Counsel for the Consolidated City of Jacksonville. And thank you.
Mr. Gabriel, welcome. Please, is there anyone else for this matter?
Lasikia Hodges from my office is also here. She's a Deputy General Counsel. So
Great.
it's just the two of us.
Ms. Hodges, welcome. Glad to have you. Commissioners, there's a little handout being sent around, something I believe received by the commission yesterday, and that is from, I believe it's from Mr. Gabriel. So anyway, welcome, glad you're here, and Ms. Klanke, please proceed.
Good morning, Commissioners. Caroline Klanke, Commission staff. We have a bit of a procedural anomaly with respect to the consideration of opinion number 2734. Because of the unique set of facts underpinning this analysis and the arguments raised by the requesters, on behalf of the City Council members, we believed that it would be more fruitful and beneficial for your consideration to have 2 fully realized analyses before you for your consideration today. They are in the form of alternative opinions A and B. I will present the facts associated with both analyses and then provide the statutory analysis and the contradictory conclusions that are present in either. Or rather, the alternative conclusions, because one would supplant the other. Opinion 2734 arose from a request from the General Counsel and Deputy General Counsel of the City of Jacksonville made on behalf of 3 City Council members whose terms will expire on the City Council on July 1 of 2019. Each of the members have expressed an interest in seeking and obtaining employment with the City of Jacksonville's executive branch departments. However, they clarified that any employment with the city would not begin until after their term has expired, but would transpire within the 2 years following their leaving public office. Pursuant to its charter, the City of Jacksonville is a consolidated government having powers divided amongst the legislative, executive, and judicial branches of government. As such, the requesters contend that the consolidated government exists as one single unitary body politic or political subdivision. The City Council, upon which the members currently sit, is vested with all legislative authority, including the power to approve the annual budget, as well as the authority to confirm all executive department heads and chiefs. The requesters state that their interactions between the executive branch department employees and the City Council are commonplace, and that council members are constantly being informed by executive branch employees, especially department chiefs and heads, regarding city projects and department budget concerns. That brings us to question 1. Question 1 in your analysis asks whether a prohibited conflict of interest would be created under either section 112.3137A or section 112.313 subsection 10 were the members to apply for public employment with the city's executive branch and to be provided the opportunity to be employed thereby. Both alternative opinion A and B reached the identical conclusion that no conflict of interest would arise under either statute. As noted in the analysis, section 112.3137A prohibits a public officer from having certain conflicting employment or contractual relationships. In addition, section 112.313 subsection 10 prohibits one from holding public office on a board that is, at the same time, his or her public employer. Here, because the facts indicate that if selected for executive branch positions, the council members would not begin their employment with the city until after their term is expired, their prospective employment would not give rise to a prohibited conflict of interest under either statute. Thus, both alternative opinion A and B provide that the employment of the city council members with the city is permissible once they have left public office, even if the employment occurs immediately following that vacation of public position. Question 2, however, goes on to address the issue of what restrictions, if any, apply to these former city council members once employed by the city. In particular, question 2 addresses whether section 112.313 subsection 14 that creates and sets forth post-employment revolving door restrictions on certain individuals that hold elected public office would prohibit the former city council members from representing the executive branch before the city council within the 2 years following their public office. This prohibition prohibits an elected member of a municipal government, here the city council, from, quote, personally representing another person or entity for compensation before the government body or agency of which the person was an officer for a period of 2 years after vacating that office, end quote. In the instant matter, were the former city council members to be selected for employment with the executive branch with the city, they would be doing so in a paid capacity, i.e. for compensation, and they would be employed within 2 years after vacating public office. Thus, the primary issue in both alternative opinion A and B is whether the term another person or entity contained within section 112.313.14 would prohibit the representation of a department of the executive branch of the city government before the legislative branch, the city council, of the same city wherein they held public office. In prior advisory opinions involving this statutory post-office holding restriction, as well as a substantially similar post-office holding restriction applicable to former members of the legislature, contained in section 112.313.9A3 and Article 2, Section 8 of the Florida Constitution, This commission has found that the term another person or entity within the prohibition includes the post-office holding representation of both private and public sector entities. Most recently, in analyzing the term another person or entity contained within section 112.313 through section 14, in CEOs 13-10 and 16-15, the commission has said that the term includes the representation of any legal person or entity distinct from or not synonymous with your natural person or self. As the statute does not distinguish between different types of entities, which are undeniably legally distinct from the public officer's own self, the commission has declined to read such distinctions into the statutory language. However, although the commission has considered the parameters of this post-employment restriction contained in subsection 14 in the context of opinions involving prospective post-office holding employment with for-profit entities, non-profit entities, and on one occasion, a school district direct support organization, we have not previously considered facts, as here, involving the application of the statute to employment opportunities existing within the same government in which one held elective office. The requester's argument, which will be elucidated more comprehensively by representatives of the City of Jacksonville's General Counsel's Office, provides that the City Council members should, in the unique facts involved herein, be able to be considered for the employment positions within the executive branch, be able to be employed immediately after the council member's term expires, and in that employment be unfettered by the post-office holding representation restrictions contained in section 112.313.14, and thus able, once employed, to freely represent their respective department of the executive branch before their former agency, the City Council, as well as the Chief Administrative Officer. The thrust of their argument is that the 2-year limitation on former City Council members not representing another person or entity before their former agency or body thereof is not applicable to circumstances where such employment is within the same governmental body politic wherein the same unitary governmental interests exist. That brings us to Alternative A. Alternative A adopts a portion of the requester's argument in finding that the post-office holding restrictions contained in section 112.313.14 does not prohibit, during the 2 years after leaving public office, a former City Council member from being employed in a public capacity with the city and representing the city and its departments before the City Council or others of their former body or agency. The analysis in Opinion A is predicated upon the finding that a former elected official is not representing, in reality, another person or entity when approaching the same city wherein they held public office in the fulfillment of their executive employment duties within that city. This analysis recognizes the factual reality that the representation made by a former public officer before the City Council in the context of public employment with the department of the city's own government does not necessitate the prophylactic restrictions set forth in section 112.313.14 as the representations ultimately and exclusively serve the interests of the city government itself. Alternative B. Alternative B finds that the former City Council members may work for the city as executive branch employees. However, pursuant to the post-office holding restrictions contained in section 112.313.14, the former members would be prohibited from representing another person or entity, including their department of the executive branch of the city, before their former agency, the City Council, as well as the Chief Administrative Officer, and the immediate support staff of both during the 2-year period immediately following their public office. The analysis of Alternative B declines to construe the term another person or entity so as to create an exemption for the representation of governmental entities located within the same political subdivision. In accordance with the analysis set forth in previous opinions such as CEO 09-4 and CEO 90-4. It acknowledges that the executive branch departments and boards of a government represent a variety of interests, some of which may compete for scarce governmental resources, and thus are not entirely unified with those interests of the City Council, their former agency. Opinion B also supports the application of the post office holding restrictions in this context because of the continuing purpose of the prophylactic restrictions contained in the statute as preventing influence peddling and the use of public office to create opportunities for personal profit immediately after a person leaves public office, of mitigating the appearance of impropriety by preventing public officials from exploiting special influence gained by virtue of their public office position within the sensitive 2-year period, and to restrict interactions between former public officers and their former colleagues during that 2-year period. Although Alternative B recognizes that the council members and requesters here are simply trying to continue their career in public service for the benefit of the city that they care about. It provides that absent the application of the post office holding representation restrictions, the potential opportunities for undue influence with their former agency, the City Council, would still be present even under these factual circumstances. As such, Alternative B finds that the representational restrictions should apply even to their public employment within the executive branch departments of the city during the 2 years after they vacate public office. Staff is available to answer any questions you may have, and it's my understanding that the city would also like to further elucidate their analysis.
Members, do we have any questions for staff counsel? Commissioner Burke.
Quick question. The memorandum that we have just been provided, does that affect the written analysis that we have in either A or B?
The analysis in both A and B contemplates, we received the correspondence that was provided to you this morning. We received it yesterday afternoon. It is illustrative of their arguments which were raised in their original request, which is provided beginning on pages 22 of your materials after opinions A and B. Both opinion A and B include a synopsis of the salient points of their analysis. However, these documents are more complete representations of that requester's arguments.
And the next question that I'd like to ask is, it's not often that we get two separate opinions of A and then B to vote on, but is that because there's split analysis by the staff or the attorneys from a legal perspective?
Not necessarily. It's because these are novel facts requesting a new interpretation, one which is persuasive, and thus, although not previously adopted in the context of this statute in prior opinions of this commission, is one which we thought deserved a fully realized analysis under both a yes and a no for the purposes of the consideration of 31314, so that you would be free to surveil the entire legal landscape that supports it.
Commissioner Lesnoff.
Can you tell me to what degree this situation is analogous or not analogous to the state government where members of the legislature are appointed as agency heads? Because it seems analogous to me, but I may be missing something.
That is correct. And for that reason, we do cite and hearken back to, in both analyses, some of the preceding analysis that preceded, for example, CEO 05-14, where we first looked at the post office holding representational restrictions contained in 31314. We looked for guidance at the analysis that preceded it with respect to 112 through 9A3, a post office holding restriction that is uniquely applicable to former legislators. And opinions such as 90-4 and 09-4 and even 81-57, wherein we had former members of the legislature being hired in executive branch positions, such as the general counsel for the the general counsel for the governor's office, or the head of the Department of State, or a community college president. Those positions, in part, require them to make representations in the 2 years immediately following their public office with the legislature. And in those analyses, we said that the post-employment restriction contained, both in the Constitution and in that statutory provision, would prohibit them from making those types of representations. However, we also contextualized that a liaison, for example, AA 1-57, could be a facilitator of those communications and those contexts. But we still applied the post-employment restrictions.
Commissioner Rosanka.
The memorandum presented by the City of Jacksonville references that that they're unique from the other 66 counties because they're the Consolidated City of Jacksonville. Can you address that argument, please?
Absolutely, and this is something that I know that they would have a deep desire to convey to me personally in their recitation. But the charter of the City of Jacksonville is unique in that it creates a consolidated form of government. That consolidated government's authority, though, is broken up into these branches. But unquestionably and repeatedly throughout that charter, it reasserts the unitary, singular political subdivision that exists in that locality. And in their analysis, they believe that that strengthens, almost to the exception, it strongly supports their assertion that the post-employment restrictions shouldn't apply because an employee of the executive department is in the exact same unitary column as that of city council itself. And so their interests in a consolidated government are the same.
Any other questions for staff? Seeing none, Mr. Gabriel, please come address the commission.
Good morning. Jason Gabriel, General Counsel for the Consolidated City of Jacksonville. I appreciate your time here today, and just a quick thank you to Ms. Clanky and Mr. Anderson. They're always extremely responsive and helpful for all the various officers in Florida seeking guidance on ethics, so I appreciate their responsiveness and help. Commissioner Rosanka and Commissioner Lesnoff have hit on, I think, what goes to the heart of the matter in distinguishing the issues at hand here for the Consolidated City of Jacksonville versus the state legislature or possibly even other counties and local governments. The rule, just to briefly restate it, is that a former council member cannot personally represent another person or entity for compensation before the government agency, their former government agency, for a period of 2 years. In the supplemental materials that has just been distributed to you, I think we've broken up the rule into 5 parts. I know previous commission analyses actually break up into 7. I think that's neither here nor there. The point of the matter is that the very terms that are employed in the rule are precisely the framework that we are utilizing for our analysis that advocates for the position that there is no conflict here. And what I mean by that is, and this is where there's a big distinguishing factor, I think, at the municipal level, particularly in Consolidated Jacksonville versus the legislature, because, and for 2 reasons. Number one, in the state legislature versus state departments and the executive branches at the state level, the rule in 112.313 is actually a different subset. It's I believe, subsection 9 versus 14, which is at hand here. And they're substantially similar, except that I'd submit that the word agency used at the state subsection is different from the way that the word agency is used in 14, which is applicable to municipalities like the City of Jacksonville. Because agency, as defined for the municipal government in the City of Jacksonville, actually includes not just the former council, the former legislative body, but in fact, it goes on to say the chief administrative officer. And for purposes of Jacksonville, that's the mayor. The mayor, by definition, in the charter, legislatively approved by the state legislature, the mayor is the chief executive officer. So that ecosystem of terminology encompasses the council member leaving the legislative body and in fact going and working for the executive branch, which is all unified in the city of Jacksonville. So to just summarize that point, the very statutory terms used in the rule, quote, agency, quote, entity, quote, client, in various parts, agency, client, entity, in Jacksonville are all the exact same political subdivision, the city of Jacksonville, the consolidated government. And so with that premise, the various terminology used in the alternative B, which would bode against or would bode for finding that there would be a conflict in this context. I'll use some of the terms used and I'll tell you why it's different here in the city of Jacksonville. Terms used for justifying why there would arguably be a conflict are that there are separate clients, that there are varied interests, that there are a competition of interests, that there are competitive advantages between various branches coming before that former body. And I'd submit that in Jacksonville there are none of those things in this unique situation where a council member leaves the council and then goes and works right across the hall at the executive branch. I would submit it would be a completely different analysis had we come here to justify, for example, a council member leaving the city council and then going and representing the city of Jacksonville Beach, which, again, I know Jacksonville is pretty unique because the city of Jacksonville Beach is actually a city within a city. So the city of Jacksonville is a consolidated government and is Duval County for purposes of the beaches in Jacksonville. So we actually have 4 municipalities within the city of Jacksonville. City of Jacksonville Beach with their own mayor and governmental apparatus, City of Neptune Beach, City of Atlantic Beach, and the town of Baldwin. In each of those contexts, they have their own mayor and their own staff. I would submit this in the very same sort of factual scenario, except council member not going to the executive branch, but in fact going to one of those cities, I believe arguably there would be a conflict. But going into the executive branch, I would submit would not be. And I think the analysis goes into things such as, for example, the budget. Well, the mayor proposes a budget. There's various branches. The heads of those branches appear before the council in order to give informative answers as to what their various departments are doing. But at the end of the day, it's the mayor, the chief administrative officer, that in fact proposes a budget, council takes it, they adopt, they amend. It's subject to the mayor's line item veto. But at the end of the day, the propositions that come out of the city council are one and the same. Even in Jackson, we have 19 council members. Whether it's a 10-9 vote or a 19-0 vote, at the end of the day, what comes out of city council is either vetoed or not by the mayor, overridden or not, and is one proposition. And in the city of Jacksonville, that one proposition, that one unified set of interests, whatever it is, the budget, a policy, a regulation, a contract, those are the voice of Jacksonville. And in fact, in a different scenario, the Office of General Counsel, which is our office, we are tasked with, in fact, prosecuting, defending, litigating, those unitary propositions that come out of this government. It doesn't matter that all the quibbling thereunder before it came out, that people had different ideas and different thoughts and different votes. The fact is, what comes out and what's tempered out of the city of Jacksonville, budget, policy, or otherwise, is unified. The interests are unified. There are no variety of interests that are at hand in this unique setting. And for all those reasons, we would submit that in this scenario, again, very unique to Jacksonville, and in fact, even more so narrow to the situation of a council member leaving that body and then going to the executive branch. Only in those scenarios with respect to the circumstances here, would we argue that, that 313.14 2-year prohibition would not, a mechanical reading of that would not prohibit their representation before their former body in that context. And thank you for your time, and I'm available for any questions you might have.
We have some questions for our requester, Commissioner Brady.
So your position is that the city of Jacksonville, Duval County is one where harmony reigns supreme, and that there are no difference of issues between councilmen with each other or between the council and the mayor?
To Commissioner Brady, and I sense a little bit of sarcasm in your question, and I get it. And let me be a little nuanced about that. I am not suggesting that there is not a difference of opinion amongst all the members, the folks that you've mentioned. Absolutely, robust differences of opinions. What I'm submitting here is that, despite that and all the discourse that leads to whatever regulation or ordinance or budget, at the end of the day, once those are approved, no matter how the vote was and no matter how many arguments were had, that is the legal unified set of interests that at the end of the day, good, bad, or indifferent, would be defended and would be the voice of the city as a whole. So I'm speaking from a legal standpoint that would be the unified interest, not necessarily that they're unified in their opinions.
Commissioner
That's
Brady.
how democracy works anyway, right? You know,
Sure.
whoever wins, wins, and that becomes the unified position of the city. Let me ask you a second question. If the people who constructed the consolidated government of Jacksonville didn't believe there was any difference between a legislative and an executive branch, why didn't they create a parliamentary set of government where the executive and the legislative are in essence a single body which can do that? Where it would seem to me that when, or at least in our tradition of branches of government and checks and balances, that the very thinking in terms of creating governments like this is to really allow checks and balances and some separation of powers so that no position becomes more powerful than another, irrespective of the desire to have a unitary government that speaks with a single voice.
Sure, to Commissioner Brady. Absolutely, and they certainly could have set up a construct where, and we see this in other jurisdictions, you know, you have a county commission and there's a county administrator that's right there that the county, the county commissioners actually approve, and then there's usually some buffering, as to, you can't fire them unless there's waste, fraud, or abuse, et cetera. You are correct, absolutely, in that the city of Jacksonville was created with very traditional separation of powers divisions. And let's put the judiciary out of it. We don't have a court system in there, obviously. We do have a unique binding opinion apparatus for the general counsel's office, but it's an executive and legislative branch and traditional sort of functions there. Executive branch administrates, operates, and executes the policies that the legislative branch approves, but and checks and balances and everything that are therein. But you are correct to submit that there are those differences and those divisions. However, for purposes of the statute, and we're reading a statute that has penal qualities to it, so we obviously narrowly construe it. I'd submit it's actually interesting when I'm reading the statute here, the fact that the legislature actually, when they created the definitions, and I've broken it up in those 5 parts on the sheet in front of you, the last part, I've numeric 5, they have defined, and it's in the statute, it's not even us going to Black's Dictionary, government body or agency, the one that you're not supposed to come back before, as not just the commission, but in fact the chief administrative officer. And in a sense, it's almost like someone from Jacksonville wrote that, because for whatever reasons, when the legislature was creating that language, and again, it's a little different than the other part in 9, which deals with the state level. they have included not just that former body, but in fact the CAO, which is the executive branch in Jacksonville. And so in our reading of this, that entity is exactly the same entity that then in another part of the statute is another agency. It's the executive branch. And I'd submit also that there's probably a more, I would say this is even more narrow to the statute than a previous opinion that was before you in 1203, where you had a direct support organization, a separate foundation, where a former school board member was allowed to go and be employed by that organization and in fact represent before their former body in that 2-year period, a completely separate organization, unlike in Jacksonville, which is the same, because there was a finding of a unified set of interests. In that case, the foundation had the same unified goals as the school board in that they supported public schools. And I'd submit that in Jacksonville, in this scenario, the executive and legislative branches are more tied and threaded together.
Thank you.
Commissioner Carbajal.
So that I can better understand how unitary works in what you're talking about, do you represent the executive or the commission as general counsel?
To Commissioner Carbajal, that again, I love these questions. This is exactly on point in that our office of general counsel, and I have to explain this to a lot of attorneys on the outside because it's not intuitive right away. Our office of general counsel represents both. And not only that, I'll go a step further. We represent the executive legislative branches, really the construct of the city of Jacksonville and all the departments therein. We also represent the independent agencies, the utility, the JEA, the port, the aviation authority, the school board, and a variety of other interests, which, of course, that's not at hand here.
Let me clarify, when there has been a conflict, how are the people's interests protected if the commission objects to the executive? Is it resolved internally, or are they two entities in the eyes of the courts?
So so what we have in the city of Jacksonville actually is, well, that's where the Office of General Counsel actually comes in. This is a legislatively approved charter provision where, and this is a power that I have with the Office of General Counsel as long, and whoever my successor or predecessor may be, there is something called a binding legal authority in the city of Jacksonville where when there's a conflict between when I say agency, I'm talking about the independent agencies that I just mentioned and the city. There could be a conflict between, by the way, our constitutional officers, the sheriff, tax collector, property appraiser, and all the supervisor of elections. They're all also part of what is known as a consolidated government. If there's a conflict, there is a binding legal authority where I'm able to actually, of course, with proper analysis, issue in writing a binding resolution of the issue. It's to eliminate, it's actually in our charter, to eliminate intergovernmental litigation and to provide for efficiencies, et cetera. Typically, that formality doesn't come into play because, as you would probably imagine, there's a lot of discussion to try to resolve matters without resorting to that formality, but that does happen, and that's how it's resolved. So there's no intergovernmental litigation. In fact, in the city of Jacksonville, the only way for any of these various parties I've mentioned to be able to sue the city itself is to actually come to city council and get their permission to do so.
Commissioner Meggs.
I recognize that all the council members in Jacksonville are people of integrity and would never do anything wrong, but let me just kind of give you a scenario that bothers me a little bit. Suppose you have a commissioner who has aspirations to, I could say, work in your office or be in charge of, or be working in the roads and highways department or the waterworks department, and being a person of great integrity, they contacted the head of that agency and said, you know, I'll really help you with your budget and give you all the things you need to do, but I'd sure like to be your administrative assistant when I don't run for office anymore. And lo and behold, their term expires. Next thing you know, they're the chief assistant to the head of waterworks, making a sizable salary. you see a scenario where that would take place in your consolidated government? And if there was a 2-year waiting period, they might move on to something else. But if there was not, they could immediately go there and accomplish great things for themselves personally. I don't know if that made any sense to you. It did to me, but I'm just throwing it out.
Through the chair to Commissioner Meggs. No, hypothetically, I could envision that sort of factual scenario. And I would answer that in 2 ways, one legally and one practically. Legally, I would submit that there in fact is another section in the statute that deals head-on with that very issue, misuse of position. So I would submit that if that were to have happened, hypothetically, that is a misuse of position and an ethical violation in that scenario. So it's just yet another provision that would be tripped. That's the legal answer. And then the practical one I would submit is, I suppose with those shenanigans, I'm doubtful that the executive branch or the person heading up that particular department would be excited about someone like that coming and working for them. I would tell you that, in as much as that very well may happen in some places, for the most part, my observation of politics and human behavior, someone like that would not be hired by a department head, if that's how they're operating. But that's neither here nor there.
That has not been my experience. So be it.
There's a lot of difference between Tallahassee and Jacksonville. I think Mr. Gabriel might mention Commissioner Meggs. Yes, Commissioner Rosanka.
I have a series of questions, and I practice in governmental law. I do a lot of zoning work and land development, so my questions are probably going to be a little pointed based upon my experience in different municipalities. First, does the city of Jacksonville have a city manager?
To Commissioner Rosanka, it's not called a city manager. The best equivalent is actually a titled position called CAO, the Chief Administrative Officer, who basically serves as you could call it county city manager.
Does that person serve the mayor?
Yes, that person is appointed by the mayor, correct.
You mentioned that the sheriff has no independent counsel. Your office represents the sheriff as well?
That's correct, yes. I will tell you, there are times, and especially if there's conflicts or a niche area, we do get outside counsel, but for all practical purposes, yes, we are the named counsel for the sheriff.
I was getting outside counsel. I haven't jumped there yet. Yeah. So if the sheriff comes to the city council and says, we want to sue you, and the city council gives permission, and the sheriff would have to hire their own counsel, correct?
Yes, we would do a determination as to, representation, and because our office, the general counsel, actually is the one that would hire outside counsel, so we would make that determination. But most likely in that scenario, yes.
Okay, and you had mentioned you hire outside counsel, and that's when you had first said the mayor can veto the council action. So what happens if a council member comes to you and says, we want to do this, and the mayor says, well, I'm going to veto that? How do you advise both sides?
Yeah, that's, I haven't had that one,
okay.
but that very well could happen. And what we would typically do in a situation like that with that sensitivity, and we do, in the office, we've got 42 plus attorneys and outside counsel. So it just depends on the circumstances. I may even get outside counsel in a scenario like that, but what we typically do is Chinese wall. I'll usually have an attorney, whether it's outside counsel or someone in the office, representing, the interests of the mayor's decision to veto or not veto, and then the same with the council. Now, I say that making it sound like it's adversarial, but at the end of the day, the Office of General Counsel represents both sides. There is some, I would submit that if you even look at the ethics rules for professional responsibility for lawyers, in fact, when it gets into a government context, and even when the commentary, we've read all this stuff, it actually at some point, I'm summarizing, but says something to the effect of things can get so complicated in internal government that that transcends the scope of the commentary of these rules, and it ends there. So there's cases actually that speak to some of these internal governmental situations where you have a prosecutor and an advisor to a board all in the same office. So going back to your question, I would typically try to sort it that way. as general counsel, I get to know and listen to both sides and try my best to try to resolve and settle the issues. But we would do that. But at the end of the day, what would happen is we'd probably, assign separate attorneys if that eventuates into litigation.
I have one more question, and this is just something that I experienced recently, is I had a vested rights hearing before a special magistrate, and it was involving Natural Resources Department of the county. And they hired their own, the council, the county commission hired an attorney just for the Natural Resources Department, because if litigation went forward, their opinion was they may have to disagree with the Natural Resources Department. Have you ever had that kind of circumstances where you have to hire for an individual department because of concern about the council?
No, never for individual departments. The closest to that scenario we've had is, and this is the closest we've had in general to one part of consolidated government potentially suing the city, is the property appraiser, who's a constitutional officer. We've come close. It's never happened. Well, it has happened, but it hasn't happened under my tenure there. It may be over 10 plus years ago, but and it typically comes around in budget time, because the budget of the property appraiser, and all the budgets in the city of Jacksonville are approved by the city of Jacksonville and the council, but the property appraiser actually has a statutory quirk where they get an approval from the Department of Revenue. And so there's this little bit of a kerfuffle that happens sometimes, especially during harder times of budgets, where the council, believes it has a little more power than the Department of Revenue. We get this little conflict. And so it's come to the point where we were about to hire counsel to represent the property appraiser as they were seeking permission to the council to sue, and the council was about to give them permission to sue because we're going to fight it out. But it got resolved, and that didn't happen. But that's the closest, at least in my observation in the past several years, that we've come to some sort of intergovernmental lawsuit like that.
Thank you.
Mr. Carvajal.
Just so that I understand, what you're suggesting is Resolution A or B your preference?
And as far as our position and what we've provided you, our analyses would bode with A, which would find that in this unique circumstance where the board member goes and works for the executive branch, that there would not be, that the conflict provisions of 313.14 wouldn't apply, or at least the definitions wouldn't apply in this scenario.
Any other questions of Mr. Gabriel? All right, thank you, Mr. Gabriel.
Thank you, I appreciate it.
Ms. Clanky, is there anything you would wish to follow up on?
Just to clarify, CEO 12-3, which he cited to, with respect to the analysis that did apply in the post-employment restrictions in 112.313.14, we did find that the direct support organization, that fact involved a school board member going to work for a foundation that was a direct support organization that had one purpose and was created by the school board. In that analysis, we did say that it was another person or entity that person would be representing. However, we applied the construction provisions of 112.313.16 to negate the effect as a remedy to the mechanical application of the statutory restrictions. And it was based on the fact that the unified goal of raising money for the school board, which was her former agency, was the sole purpose of the existence of that organization. As we cited that as the reason for applying the equitable remedy of 112.316, not finding that 313.14 didn't apply at all.
Any questions for our staff?
Mr. Chair, a question for you and the General Counsel. Are we obligated to answer question 2?
General Counsel?
Yes, I believe we are. They put it forth as a straightforward question. It's not one that I think could be avoided. It's really the meat of the inquiry.
Nice try, Mr. Commissioner Carvajal, but.
So just to clarify what I just heard, for other situations in the future, any question that is posed to the commission must be answered?
Let's don't
Through
jump
through
to
the
that
chair,
conclusion.
through the chair, if I might.
Yes, please.
Thank you. In the context of advisory opinions, it's not like, say, the U.S. Supreme Court, where you actually have to have a case or controversy to render a decision. These things are advisory, but the questions do have to be real enough or concrete enough and pertaining to particular people and issues enough to be answered. So we don't answer things that are purely speculative or too amorphous, but typically we don't turn down a well-made, good faith request.
Commissioner Rosanka.
I don't know if this is more of a comment. We did have one matter where we chose not to answer one of 5 questions. So it is possible, and I don't remember if that's because we were deadlocked on it, but there have one I can recall.
My recollection is that was a speculative issue, but maybe not. Executive Director?
I think the one you were referring to was that it was somewhat speculative, and to the extent it was not, it was answered by the other, in the balance of the opinion.
Okay, so, Commissioners. Commissioner Brady?
So in terms of a motion, we need a motion that would choose either alternative A or alternative B rather than the motion we usually make, which is either to approve or deny the staff recommendation.
Yes, we will. We need a motion to approve or deny the staff recommendation, but specific as to alternative A or B.
I would move to approve the staff recommendation and alternative B.
Second.
All right, we have a motion by Commissioner Brady, a second by Commissioner Rosanka to approve alternative B. Any discussion? Commissioner Carvajal, thank you.
And I wasn't trying to avoid it. I do think that the novelty is actually interesting here. Not moved by the case of public service, because by leaving question 2 unanswered, they can choose individually. And it apparently seems that they have a strong general counsel's office who could advise them on what to do. And I'm not saying that facetiously. I think that Duval is unique with its charter. I probably will vote in favor of B as was recommended here, but there are compelling reasons to believe that this is unitary. And most of our comments and concerns seem to be about how we feel about that rather than the instant situation. But it's just a general comment about how I feel. I don't know if anybody else wants to be persuasive on the unitary, so I know to reject this and vote in the other direction.
Commissioner Berger.
I start looking at this with whether or not we're precluding someone from public service, and when you look at the elements, it's for compensation before the government body or agency which a person was an officer for a period of 2 years. So I don't view it as precluding service. Then I move on to the legal analysis, and I have a mixed legal analysis. I've got 2 sides, which is rare. First time I've heard it here. I got 2 opinions on the legal analysis, and I look at our function as a body, which we are the State of Florida Ethics Commission. And I look at, we've got many cities, many counties within the state, and I view this, I feel that B is the appropriate way because I think A is bad precedence. I think it opens up floodgates for other cities or counties within the state to make this argument, and I see more of it as a uniformity issue and or a carving out an exception, which I side with. I've got 2 closely argued positions of law, and I view B as the appropriate position for me as far as a vote.
Any further discussion, Commissioner Rosanka?
Just briefly, and I struggle with this because this is something novel, but I'm still hearing conflicts exist, and I'm still hearing the potential for people to try to lobby within the unified government, and that's where my concern falls in. So that's why I'm supporting B.
Any further discussion, Commissioners? All right, seeing none, we'll call the question. Okay, the motion is to adopt alternative B of the staff opinion. All in favor, please say aye.
Aye.
Any opposed, nay. Motion carries. Mr. Gabriel, thank you very much. We appreciate that. Not sure that's the answer you wished, but it's the answer of the commission. Our next item is file 2735, conflict of interest doing business with one's agency, water management district governing board members, companies doing business with the district. And beloved General Counsel, Mr. Anderson, I believe, is up on this one.
Thank you,
Do we have
Mr.
the requester here?
Yes, sir, Mr. Chair. Mr. Pozzawali and Mr. Holroyd, I believe it is, counsel for the requester are present.
Welcome.
Thank you, Mr. Chairman. There are actually three questions in this opinion. This deals with a person who may very well become a member of the South Florida Water Management District, but they wanted to seek an opinion and make sure everything was in good shape ethically before that was done. The first question has to do with contracts that companies that the member is connected to already have with the Water Management District, and based on many opinions in the past, as well as plain language of a statute that's at issue, you essentially have a grandfathering of the contracts that predate one's appointment to office, and that's just because, you know, if you weren't in there when the things were entered into, then how could you have affected, you know, the desire to contract with your own company? So that's pretty good logic and a pretty sound history in those opinions. So basically the grandfathered contracts are not a problem for him, and that's question one. Although if the contracts are renewed or extended in the future, there are some strictures that may apply that are explained in the detail of the opinion, but essentially you have a grandfathering of existing contracts. And then question two is, well, what if there are new contracts entered into after the person becomes a member of the Water Management District? And the prohibitions generally applicable to contracts that happen between you and your companies after you are a public officer typically tend to ignite the bring up the prohibitions of 112.313 subsections 3 and 7A. And so without an exemption, a new contract would be a conflict. However, there are a number of exemptions to conflicts for new contracts, and one of which is seal competitive bidding to the lowest or best bidder, where a form of disclosure is filed by a certain time, and the official stays out of determining the bid specs or the determination of the lowest or best bidder. And that is a standard exemption. It has a standard form for it. It's very well understood. Competitive bidding for purposes of that exemption, as the opinion recognizes, cannot be like an RFP or an RFQ or some sort of invitation to negotiate things that are commonly referred to as bidding. It has to be true seal competitive bidding to the lowest or best bidder in compliance with the statutory requirements using Commission on Ethics Form 3A. And I believe the intent here is that any new contracts would follow that competitive bidding exemption. There are some other possible exemptions that might come into play, but I think that's the one mainly in focus here. Again, that's a pretty standard answer. Then moving on to question three, the issue there is whether or not a company to which the person is connected could lease or sell realty to the Water Management District after they get on the Water Management District Board for a project that the district has concerning the restoration or restoration efforts toward Biscayne Bay. And question three, you do have the prohibitions of 112.313 subsections 3 and 7A that are there, but you have the sole source exemption, which the Commission on Ethics has found in several cases to apply to purchases or acquisitions of interest in realty, which would be what would be happening here. Key to the sole source exemption is that there be objective determinations by the agency staff that, this is the property we need for the project, and that there be no, involvement of the member that is connected to the private entity that has the realty, trying to influence staff or that sort of thing. It's all laid out in the opinion. And if the requirements of the sole source exemption are followed, then a new contract entered into after the member takes office that falls within the requirements of the sole source exemption will not violate the statute. It's a pretty standard thing. We've been here before on these kind of things. They've been real straightforward with their factual presentations and met with us early on, and I've had a pleasure dealing with them, and so this opinion is offered for your consideration, and if you have any questions, I'll be happy to try and answer them. Thank you.
Any questions from the commission? Commissioner Brady?
Is there an issue? This is a very public discussion. You read about it in the paper all the time. There's no secret information that I'm aware of. But if he's appointed to the person is appointed to the board of the Water Management District, and the district continues to maintain a business relationship with his entity, that doesn't construct, I guess, what we've called a kind of a perpetual conflict of interest? I mean, we've had some cases where we've had commissioners who have businesses they were into prior to becoming elected, and they've maintained those relationships, and we've had complainants who say, look at this is a conflict of interest, and I think I'm not clear how we always vote on those, but the fact that he is on the Water Management District Board, the Water Management District Board is doing businesses with his interests, and that his role on the Water Management Board at a minimum would probably be to review the assessments of how that work is going. That in the statute doesn't create a conflict?
If I might, through the chair.
Please.
Commissioner Brady, what we have there, that mainly goes to the fact that 112.313(7)A has two parts. The first part is the business-oriented part, and the second part of that prohibition could go to impediments or continuing or frequently recurring conflicts. And the history of the decisional history of this commission, as well as the fact that Form 3A is promulgated and reads the way it does, is that the business or the vending interface of services or the lease of realty, that this vending interface is the kind of thing that can be covered by these exemptions. And there are situations, for example, where there might be something come up later that could trigger the second clause of 7A, but the pure vending of it is not a problem. And the opinion also speaks to the fact that the member would have to refrain from voting on any matter or participating in any matter that would affect him or his company should that come up.
Thank you.
Any other questions for General Counsel? All right, seeing none, we'll hear from our requester, Mr. Puzzoli, I believe it is. Welcome.
Ed Puzzoli with Tripp Scott, representing, since it's not a secret, Commissioner Brady, Ron Bergeron, Senior. I have not a whole lot more to add other than that we understand the recommended opinion from staff, and we'll proceed accordingly, assuming the commission approves it today. I stand here before you open-handed and fully transparent, so if you have any other questions, please feel free.
Any questions? All right, seeing none, thank you very much.
Thank you so much.
Appreciate your attendance. All right, what is the pleasure of the commission?
Move to adopt the staff's recommendation on the opinion.
Second.
We have a motion, Commissioner Brady, a second from Commissioner Rosanka. Any discussion? Commissioner Berger.
I mean, the opinion speaks for itself. It's laid out, the law, the statutes. We have an obligation to follow the law and the statutes. I just want to touch on what I think Commissioner Brady was trying to get at, which is there may or are foreseeable issues that may arise in the future where disclosure, abstention, recusal may come up, and I'm certain based on the publicity type that you're talking about, that obviously that would be subject to scrutiny. But as far as the opinion goes, it's very well laid out as far as the law.
Any further discussion? Seeing none, all in favor of the motion, please say aye.
Aye.
Any opposed, nay. Motion carries. The opinion is affirmed. Our next item is to be presented by Lane Johnson. It is file 2736. This is anti-nepotism, stepmother-in-law of Director of County Veterans Affairs Department in Monroe County. Mr. Johnson.
Yes, thank you, Mr. Chairman and committee members.
I think we do not, I'm sorry, Mr. Johnson, we don't have a requester with us, do we?
Oh, no.
Okay, I'm sorry. Excuse my interruption.
Oh,
Go
that's
right
fine,
ahead, sir.
that's fine. Yeah, this opinion asks the question of whether or not a public official can promote or recommend the promotion of what would colloquially be referred to as a stepmother-in-law, and or if allowing them to do so would violate Section 112.3135 of Florida statutes, anti-nepotism prohibition. And central to this question is whether or not a so-called stepmother-in-law falls within the statute's definition of a relative. And this draft opinion concludes that a stepmother-in-law is not a relative within the meaning or definition of the statute, and that mostly hinges on the fact that the statute's definition of relative does not include stepmother-in-law, although it does include stepmother. It just doesn't include the in-law part, you know. So this draft opinion is offered for your consideration, and I'll be happy to answer any questions you guys have about my reasoning behind that. But that's basically the crux of the issue, is that it's not mentioned in the statute, and to interpret it in there would be, you know, putting in putting in language that isn't in there, you know, to inferring that. So, yes. So.
Thank you, Mr. Johnson.
Any questions?
Any questions for Mr. Johnson? All right, seeing none, we will proceed. Is there a motion in favor of your in-laws?
You're not going to get a motion on that one.
I move to approve the ethics opinion as presented.
Second.
We have a motion from Commissioner Rosanka. We have a second from Commissioner Brady. Any discussion? Commissioner Lesnoff.
Yes, and I'm going to support the motion, because the statute is pretty specific about who it names. However, I have to feel that their intent was probably not to exclude stepmother-in-law, but they didn't do that, and so I'm going to go with what the law says, but I would imagine the intent would be to.
Well, there's actually a commission opinion where someone's, I believe it was their former stepdaughter, they were allowed to hire because it was their former stepdaughter. Whereas if it had been their current stepdaughter,
Right.
then they wouldn't have been able to. So, you know, this kind of distinction has been addressed before.
It's kind of interesting how one could lose your position as a child. Okay. Any further? Yes, don't pay any attention to the chairman. He's just musing along. Any other comments on our pending motion to approve? Seeing none. All in favor, please say aye. Aye. Any opposed, nay. Thank you. The motion carries. Our next item, file number 2737, conflict of interest, state university employees contracting with the university on matters unrelated to their university duties here in great city of Tallahassee. I believe our requester is present, and Mr. Schaefer is going to handle the matter. So if our requester will stand and introduce himself or herself, please. Requester. Thank you. Welcome. Mr. Schaefer.
Thank you, Chair.
Please proceed.
Commissioners, this is a pretty straightforward question. It's been brought by these two FSU employees. They both work in the university's Information Technology Services Office. In that capacity, they offer tech support to certain campus-wide services like payroll and student enrollment. But in their private capacities, they co-own a catering company. This company is included on a list of catering companies kept by the Turnbull Center, which is one of the FSU event venues. And various organizations looking to host events either on campus or in the Tallahassee area will call the Turnbull Center to get catering recommendations, and the center will then give them this list of potential caterers for them to contact. And the question here is that different university departments and offices looking to host events will also call the Turnbull Center and obtain that list. And the requesters wonder if they get a call from one of those university offices or departments if they can accept the offer and contract to provide catering services, considering the fact that they are also FSU employees. Now, on the surface, this raises some conflict of interest concerns under two statutes, some of which you've heard a little bit about earlier today. Those would be Section 112.313, subsections 3 and 7A. Subsection 3 is triggered if a business owned by a public employee sells goods or services back to that own employee's agency. Subsection 7A is triggered if a public employee has a private employment relationship with a business entity doing business with their agency. Now, a scenario where these two FSU employees have a catering company selling services to different departments and offices at the university would seem to raise concerns under both of these provisions. But in the past, you all have applied a separate statutory provision, Section 112.316, to negate the application of the conflict of interest statutes when a public employee lacks any responsibilities in their public capacity regarding the relationship between their private business and their public agency. I'd just like to read a portion of that provision to you. It says, it's not the intent of this part, meaning the Code of Ethics, nor shall it be construed to prevent any officer or employee of a state agency from accepting other employment or following any pursuit which does not interfere with the full and faithful discharge by such officer or employee of his or her duties to the state. Now, in the past, you all have applied this in an opinion very similar to this one, the advisory opinion 0712. You applied it to negate a conflict under these two provisions I'm talking about when a UF professor owned a private architectural company that was looking to contract with UF to work on a particular building project. In that situation, you considered these two conflict of interest provisions, but ultimately you found any conflict was negated because the professor's responsibilities at UF had nothing to do with the building project, and so they created no practical conflict. The draft before you recommends that you apply Section 112.316 here as well to negate any conflict of interest. These two individuals provide tech support at the university, but they have indicated they have no involvement in selecting caterers or providing catering at different university events. Because their public responsibilities seem unrelated to what they're seeking to do for their agency privately through their catering company, my recommendation is that any conflict under Section 112.313, subsections 3 or 7A can be negated. Very similar to what you all did before that UF professor. So I offer this draft now for your review. I'm happy to answer your questions, and I know the requesters will be glad to answer your questions as well if you have any for them.
Commissioner Carvajal has a question for staff.
Mr. Chair, not a question. Actually, I'd like to recuse myself because my firm often contracts with Turnbull Center and would potentially interact with these companies.
All right. We have that announcement. Any questions? Commissioner Brady.
Do we have any idea of how extensive contact between the university technology staff and other parts of the university are?
Sure. Now, they would be probably best able to answer that question, but from my discussions with them, they've indicated that they don't have any special degree of influence in any particular department or office at FSU. They perhaps work with different departments and offices because, again, they provide tech support campus-wide, but they've been pretty clear they don't have any special or particular influence with any other department or office.
Any other questions? All right, we'll ask the requesters to come forward, please. Introduce yourselves for the record and anything you'd like to present.
Good morning. Thank you for your time. My name is Chuck Stubbs.
Martin Schaefer.
And I really don't have much more to add at this point than what was presented to you.
Well, we'll note for the record that the caterers did not provide any samples to the commission.
I would like to say that we were going to, but we were told no. We have
Just don't cloud the
great
record.
counsel.
Any questions for our requesters? All right, gentlemen, thank you for coming.
Thank you.
Commissioners, do we have a motion?
Move we approve the recommendation.
Commissioner Meggs moves approval,
Second.
seconded by Commissioner Zanka. Any discussion? Forgot to ask what their specialty was, but, all right, so all in favor, please say aye. Aye. Any opposed, nay? Motion carries. The opinion is approved. All right, that concludes our advisory opinions for today's meeting. We will move into item 5, consideration of financial disclosure appeals. Item 5 on your agenda is appeals of automatic fines under the financial disclosure law. There are no appeals in which the appellant has asked to be heard. Would any member like to hear from staff as to any of these cases, or do I have a motion to entertain them en banc?
Motion to approve the recommendations in item 5 and bank.
Beautiful motion. Is there a second?
I'll second.
We have a motion and a second. Any discussion? Seeing none, motion to approve. Did I get a second? I did get a second. Motion to approve the summary staff recommendations. Please say aye. Aye. Any opposed, nay? The motion carries. All right. Next item 6, consideration of expenditure of money. I will allow our executive director to explain our expenditures.
Members, this is, we're entering a new 3-year contract with Westlaw. The monthly charges for the year, the first year will total $17,079. This is something we've planned and budgeted for. My authority to make expenditures is limited to $10,000, so I need to get your approval for the Westlaw budget.
Move to approve the expenditure.
Second.
We have a motion and a second to approve the expenditure. Any discussion? Seeing none, all in favor, please say aye.
Aye.
Opposed, nay. Motion carries. All right, item 7 on our public agenda today is discussion and comparison of state ethics agency budgets. And Vice Chairman Commissioner Rozanka has requested that this item be added today, and we'll allow her to take the lead on the discussion.
This came up several months ago, and I was more curious than anything else as to how we compared to other states and other ethics agencies, and so I'd asked that this be gathered, and staff did that. I just think it's important to recognize that we are a very important agency, that we have a lot of responsibility, more than a lot of them, less than some. We don't have finance law, but campaign finance, but I think it's, it's something we should recognize. I don't have much more to say than that.
No real complaints or, all right. Anything else? Anyone else? Commissioner Leslie?
Yeah,
I'd like to comment. I found the data interesting and informative, but I think that caution needs to be taken anytime there's an analysis of budgets between states, only because states differ so widely with respect to wages and costs of living that until those can be controlled for or neutralized, it's hard to really derive any meaning from them. But I did find the analysis complete and the distinction of what each group did quite interesting. So thank you.
Agreed. Any other discussion? Gee, I thought we'd be on this one for about an hour and a half, Kim. All right. Next item are our reports. Chairman's report. How are we coming on or I guess the chair will ask a question on the chair's report. How are we coming on our retirement for our executive director's event in which we seek to invite former members of the commission to attend? Coming along nicely? Wonderful. Chair's report is that we are coming along nicely on that. All right.
Does the chair have any idea where it might be? Or is it a surprise?
Does the chair have any idea where it might be? We're still working on that. We've got some great ideas, though, that have previously been discussed, but my familiarity with the Tallahassee haunts is a little shy. I don't spend a whole lot of time up here.
We're not doing it in Lake City?
Well, there's been an outcry for that, of course, but no, we're going to pass on the center of the universe for this, and so that Ms. Doss won't have to travel for her own retirement party. Executive Director, as you wind down your last Executive Director reports, let's make it a good one.
My penultimate meeting here. Yes, with respect to the Executive Director's report, I have only one thing, and it has to do with the pending, the cases, pending orders imposing penalties. The Speaker of the House has advised that no penalty will be imposed in the David Rivera case. We saw that in the press, and it referenced a written statement. It was provided to us saying at this time there are no plans to take any further action with regard to the Commission's findings. This case is almost a decade old. The only available enforcement mechanisms are costly, probably more costly than any fine that might eventually be collected. It is more important to devote the resources of the House to the issues the people of Florida care about most: affordable health care, quality education, and a strong economy. So we'll be closing our file on that case. And with the chair's permission, I'll just swing right into the legislative report,
Sure.
Which I'm just going to hit the ones that I actually think are really something's going to happen with, which is primarily the electronic filing legislation. That passed its last committee yesterday. If it hasn't already been put on the calendar for the House, it will be shortly. Same thing in the Senate. We have gotten that in what I think is about the best shape it can be so that we can actually implement it. Having said that, I will say that we are coming into the period of session where mischief is most likely to arise, which is where things get on the floor and somebody has a brilliant idea that hasn't been vetted in any committee or any other kind of way. And so we're going to be very alert for that. And that causes an issue that I wanted to raise, which is this. In many circumstances, or at least one over the past few years, there's an issue that always comes up at the end of session that you have spoken on. We know the Commission's position. We can go out and fight. Little things that they might want to tack on to the e-filing legislation, you're not going to have the chance to look at. So my request, I guess, or proposal, unless somebody has a different idea, we still have Commissioner Brady is still technically our legislative liaison. Our legislative committee sort of fell apart after two of the members weren't reappointed. But he's still our legislative liaison. So if I have a short notice issue that I really need to take action on, if it is acceptable to you, I'll get in contact with him, and if it's acceptable to him, I'll speak on behalf of the commission on whatever issue that might happen to be.
Commissioner Lesnoff.
Yeah, would you be able to communicate with us either via email or some way of what those urgent issues might be? I understand that things move really, really quickly, and you may not be able to wait to hear back from all of us, but that way we could at least see what they are, and if we have an issue, weigh in.
Yes, through the chair, I can communicate to all of you, but I can't take action based on what you all send me, because you can only take action in the public as a commission. So I can't kind of poll you to see how you all feel about this. I need somebody that I can get a yes or a no from so that I can go forward. But it can't be kind of like an emailed meeting where